Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia, with offices in Woodstock, Cumming, Jonesboro, and Dunwoody. I am here to talk to you today about plan modifications in Chapter 13, bankruptcy. First, I want to issue this brief disclaimer. We're a debt relief agency proudly assisting consumers in filing bankruptcy under the U.S. Bankruptcy Code. However, there is no attorney-client relationship with the viewer of this message unless there's a fee agreement. We'd have to meet with you individually to offer you applicable and accurate legal advice. This is intended only for educational purposes. So today we're talking about plan modifications in Chapter 13 bankruptcy. So if you're modifying a plan, that means we're talking about a plan that has already been confirmed. If you're pre-confirmation, that would really be amending the plan. You're amending the plan trying to get it confirmed. Now you've got it confirmed and you want to modify it. So the question would be, why are you trying to modify it? Maybe you or your spouse, your salary's been reduced, you've been laid off. So you're trying to say, I can't afford, my $2,000 a month trustee payment. Now I can only afford $500 a month. Of course, if you're laid off, you might find you can't afford anything, and maybe you want to dismiss or convert to Chapter 7. But setting that aside, let's assume you're still going to remain in Chapter 13. If you are, then you're going to try to modify your plan, and you're going to say to the trustee, well, I did have this plan confirmed, but that was predicated on me earning this salary. I'm no longer making this salary. I can't afford it. I need a modification. Usually that would be an unforeseen circumstance, and usually that kind of thing would be granted. Now you have to bear in mind, why is it you're paying $2,000 a month? If you're paying $2,000 a month because that's what you need to pay under what's called the best interest test to protect non-exempt equity, regardless of your ability to pay, you might that you can only afford $500 a month, that you won't get your plan modified to $500 a month because your creditors would get more in a Chapter 7 liquidation. So it's not always based on your ability to pay. But if the reason you were paying $2,000 a month was based on your results of your means test and you had no non-exempt assets, you just had a lot of income, excess income, in that scenario, you'd probably be able to get it modified. Now, it's got to be an unforeseen circumstance. If it's not an unforeseen circumstance, let's say you decided you wanted to keep your home in your Chapter 13. Maybe you had a little bit of mortgage arrears, so your plan was to keep the home, pay off the arrears in the plan, and now you've just changed your mind for no particular reason. That kind of thing, you're really going to be subject to the legal doctrine of res judicata. You already got into a confirmed plan. You now want to change your confirmed plan just because you've changed your mind, essentially. In that scenario, it's going to be hard to get that done. Now, maybe you can get it done. I mean, maybe the trustee would be okay with the fact, well, you are moving out, but your creditors, you might even be modifying to increase your plan payment because now you're moving from a $2,000 a month mortgage to a $1,400 a month apartment. So it's not that you can't. I mean, this is really going to vary by your district and your trustee, but you might run into problems under the theory of res judicata when you're trying to modify. So really, a big part of it's going to be, can you, what is the circumstance for your modification? Why is it you want to modify, and is it fair to your creditors for you to modify? You can also try to get what's called a hardship discharge if you're close towards the end of your plan payment and maybe your spouse passed away or something and they were contributing to income. You might then just say, what, rather than modifying, let me get a discharge because I came so close to completing the plan. But you're really going to have to be towards the end of the plan to get that done. It can't, it's going to vary by case, but can you get a Chapter 13 plan modified? Yes. But will you definitely, just because you want to, get one modified? Not necessarily. And that covers plan modifications in Chapter 13.